From Battleborn Progress, this is Out in Front. I'm your host, Jacob Solis. This week marks the anniversary of the deadliest mass shooting in American history, after a gunman opened fire on a music festival on the Las Vegas Strip on October 1st, 2017. In the 7 years since, we've seen tremendous progress in efforts to prevent this kind of violence from happening again, both at the state and the federal level. But in that same time, we've also seen conservatives in the gun lobby wield the law and the courts to try and stop that progress. Today, we take a look at what's changed since 1 October and what still needs to be done to help prevent gun violence in Nevada and across the country. Without further ado, let's get to the rest of the show. With me now is David Pucino, legal director and deputy chief counsel at the Giffords Law Center, one of the most prominent organizations nationwide in the effort to end gun violence and fight the stranglehold of the gun lobby on the American political system. David, thanks so much for being on Out in Front.
It's my pleasure, Jacob. I'm really glad to be here with you.
Absolutely. And I mean, look, to start, of course, we're having this conversation on the anniversary, and right before the anniversary of the deadliest mass shooting in American history, and one that hits close to home for so many Nevadans. 7 years later, how has the landscape of the law when it comes to gun violence changed? Have we learned any lessons sort of at the 50,000-foot view?
I think we've seen two major trends going forward. On the one hand, we've made a lot of progress at the statutory level, especially at the state level, but also we saw in 2022 the first major piece of gun safety legislation at the federal level in a decade in the Bipartisan Safer Communities Act. So we saw some really great and important legislative progress. At the same time, we've seen the courts limiting the ability of legislatures and governments to take steps to address the problem of gun violence. And that came particularly to a head in the 2022 Supreme Court decision of Bruen. We had actually within a few weeks of each other, we had the enactment of the Bipartisan Safer Communities Act and then the Bruen decision. So those, I think, are the two major trends that are really what we're trying to navigate here is forward progress that we're able to make through legislative action, and then the problem of the courts frustrating some of those efforts through these decisions.
Absolutely. And really quickly on Bruen, just so our listeners are sort of up to date on this, that essentially makes it so that any new gun violence prevention measure that doesn't have a quote unquote historical basis basically doesn't count or isn't constitutional. Is that a fair summary?
I think that goes too far. What the court said in the Bruen decision is that if you have a law that's going to implicate the Second Amendment, then that has to be supported by the historical record. So if it's within the plain text of the Second Amendment, the right to keep and bear arms, the right of the people in particular to keep and bear arms, then there has to be a historical basis in order to support any kind of statutes that would speak to and be in that space. And now it's been very difficult, I think, for lower courts to interpret what that means. And the reason why there's been a lot of difficulty there and a lot of confusion from the lower courts trying to apply this test to a whole range of gun laws that have been challenged by the gun lobby has been that the test is a novel one. This isn't typically the way that courts have done constitutional law. The way they had done constitutional law was the way that the pre-Bruen test had worked, where you identify rights and you have courts assessing the means and ends and applying scrutiny based on the constitutional right. That's how we do it in the First Amendment space. That's how we do it in the space around the 14th Amendment. And it's really a well-ingrained area where the courts have a lot of practice. But this historical test that Bruen announced really was novel and a whole new way of approaching these kinds of questions, something courts hadn't done before, and therefore and engendered a lot of confusion. You'd have the same courts looking at the same laws, the same statutory language, getting the same history and coming to opposite conclusions because it really is something they hadn't done before. So that kind of confusion has been a real problem. And I think we're hopefully moving forward with a stronger sense of what that test looks like and how to apply it, not least because we had another Supreme Court case this past term. That was the Reshaped case in which the Supreme Court, I think, very forcefully shut down misinterpretation of its Bruen decision out of the Fifth Circuit. In that Reshaped case, the Fifth Circuit, so that's the circuit court covering, amongst other states, Texas, had said that the federal law that prohibits people who are subject from restraining orders from having firearms was not complying with the Second Amendment. And so they said that that prohibition was struck down. What the Supreme Court did in the Rahimi decision was, I think, very rightfully say that decision out of the Fifth Circuit was not compatible with their Bruin test, was not compatible with their reading of the historical record, and was not required by the Second Amendment, that the Second Amendment is fully consistent with laws that prevent dangerous people from having guns.
Absolutely. And I guess just to stick with Bruin, because I think it's relevant to what's happening in Nevada here, kind of related but not related, there was a law here that would have banned ghost guns. And essentially, it was struck down by a court here a couple of years ago. They basically cleaned up the law in the most recent legislative session, but then it was vetoed by the Republican governor, in part because he argued that it would have conflicted with Bruin. So I guess, to what extent are we seeing state legislatures or governors, or I guess sort of, sub-federal lawmaking bodies trying to grapple with, interact with, or I guess sort of make politics through policy vis-a-vis Bruin, I guess, if that makes sense?
Yeah, it does. I mean, it's a great question. I think I'll back up first to talk about the ghost gun situation, both nationally and in Nevada, and that sequence of events in the courts there, and then I'll zoom back out and talk a bit about what that means. I think more broadly for how we grapple with the Second Amendment case law and how we understand our ways to pass gun violence prevention legislation, despite and in a way that's consistent with that case law. So the Nevada legislature in 2021 enacted a really strong ghost gun law. So this is a law that says that if you're selling gun parts, they are going to be treated like guns. And so you have to follow all of the laws that you would follow when you're selling these gun parts, these kits to make a gun, as if you were selling the fully completed, ready-to-go gun itself. And I think that was a really common sense policy that Nevada and a number of other states have enacted, because what you essentially had was you had some of the worst actors in the gun industry were trying to skirt our gun laws by claiming that selling a nearly finished gun meant they weren't actually selling a gun. Now, that's something that's, I think, on its face ridiculous. If you go to IKEA and you buy a disassembled table, you're not going to claim you didn't buy a table from IKEA because you have to spend an hour putting it together at home. But that is really what the gun industry is claiming. Because you had to do an hour of work at home, they weren't actually selling you a gun. So they wouldn't conduct background checks. They weren't putting serial numbers on them so you couldn't trace them. They weren't retaining the records you need for those firearms tracings. So really very egregious conduct that was facilitating people who are prohibited from possessing guns from obtaining them. So people with criminal records, children in a number of cases. They also were a really great source of guns for traffickers, because traffickers were able to get guns really easily through these channels, either ordering them online or even going to a gun show, cash and carry, walking with cash, walk out with guns. And they were much harder to trace. So when they were recovered by law enforcement in connection with the crime, it was much harder to trace them back to the trafficker and therefore to uncover and interdict gun trafficking rings. So that was a circumstance that Nevada faced in 2021 and passed this really strong ghost gun law. This case went through the court system, both at the federal level and at the state level. At the federal level, it was upheld. And then at the state level, the state court, the trial court at the state level said that there was an ambiguity in the way that the statute was defining the gun parts, and said that it was impossible for somebody to know whether a product qualified as one of these gun parts or not. Now, this was an industry talking point for a long time about why what they were doing was okay. They would say, well, the kits that we're selling, which we expressly market to make guns, are no different than if we were selling a paperweight, because the object is not yet a gun. It's an absurd thing. Nobody had any confusion about what parts we're talking about when we talk about ghost gun kits, not least of all the companies that are selling them, because they expressly sell them to say, here's a ghost gun kit, here's something you can buy and you can purchase. But the trial court did what it did, and it was appealed up to the Supreme Court in the state, in the Nevada Supreme Court. And so that case was pending before the Nevada Supreme Court. Now, in that interim period, the legislature said, well, I don't see any ambiguities. We didn't see any ambiguities when we passed this, but this court has said that there are ambiguities. So we'll be more specific about what we're talking about when we're talking about these ghost gun parts. And so the Nevada legislature passed a bill that would have clarified more specifically, used some different language to specify what we're talking about when we're talking about these parts, to resolve any quote unquote ambiguities that the trial court had found. Now, that was what was vetoed by the governor. But Nevada Supreme Court reversed that trial court and said there was no ambiguity here. It's very clear what we're talking about when we're talking about these unfinished parts, these kits. And the court there noted that the industry itself uses the same kind of terms that the statute uses to refer to these kits, refer to these parts. So there wasn't any ambiguity, there wasn't any confusion, there wasn't any constitutional problems, and the statute, as originally passed in 2021, was upheld. Now, that was tremendously important for the state of Nevada. But a problem with gun trafficking that I think everyone's very familiar with is that gun traffickers don't stop at state lines. So the fact that we have a strong ghost gun law in Nevada does not mean that Nevada is free from the problem with ghost guns, because they can be sold into other states that don't have those kinds of strong protections and then trafficked into Nevada. We see that all the time. So what we really need to address the ghost gun problem is a comprehensive national solution. Not just a state-by-state solution, because those can be insufficient when there's gaps in the states, and also because there are some states that just don't take the problem of gun violence seriously enough to pass the laws that Nevada and other states have passed. So in 2022, so the following year of the Nevada legislation, we had a federal rule coming from ATF that would close down the loophole that allowed these ghost guns to proliferate in the first place. Would have said that these parts that are sold in incomplete form, these kits, are counting as guns for federal law purposes. And that would take this entire segment of the industry that had been trying to exploit gaps in the law and say there are no gaps. The stuff that you are selling, they are guns, they are treated like guns, you need a license to sell it, you need to conduct a background check, you need to have it be traceable. And that rule has gone into effect at the national level. From the federal government. And that rule has the potential, I think, to really be the solution to this problem, because it means that everybody everywhere is going to have to abide by it. And you're not going to be able to just ship into the state next door when your own state passes a strong ghost gun law. But that law has too been challenged by the industry, and the Supreme Court is going to be hearing that case on October 8th.
Yeah, and I mean, to that point, I'm glad you brought this up, because I wanted to ask about these ATF regulations, because it's been such a major way that some of this stuff has changed. And I think when we talk about 1 October in the sort of context of that event, one of the big things that came out of it was a push to ban bump stocks, right? Sort of stocks for semi-automatic weapons that sort of turned them into automatic weapons. We saw a legislative effort, but really what ended up happening, as you mentioned with ghost guns, was in ATF regulation. But as I understand, and I'll let you explain this, right, that hit a snag in the courts, right, where it was challenged?
That's correct. So after 1 October, the Nevada legislature passed a law prohibiting those bump stocks and devices that turn a semi-automatic weapon into an automatic weapon. That's their function. That's what they do. And anyone who was present for those horrific events or has heard audio of them knows what we're talking about. It's automatic fire. That's what a bump stock does. It makes a semi-automatic weapon automatic. And so those were prohibited by Nevada and a number of states. And then action was taken under President Trump at the federal level to classify bump stocks as machine guns, because any device that converts a weapon into a machine gun counts as a machine gun under federal law. So these devices, if you could get one of them, put them on a semi-automatic rifle, you have a machine gun. It's a machine gun. And that was the action that the federal government took under President Trump. And that was initially supported by some in the industry, and then they flipped like a switch as soon as they thought that the political pressure was off and they could get away with it. And so we had a challenge to this regulation that came from the gun industry. It came from sellers who want to sell bump stock products. It's, I guess, a pretty good business for some segment of the population, no matter what kind of havoc they can wreak on the rest of us. So that was a challenge that moved through the courts and then was heard by the Supreme Court, which issued a decision on that this past June. It was a case called Carville. And there, the Supreme Court was looking at the statute, the language that was initially passed by Congress defining a machine gun, to see whether the Trump administration rule complied with that statutory language, with whether ATF had defined this product that I think everybody would casually say is a machine gun, because that's what it does, that's what it is, to say whether it was going to be formally and technically a machine gun under the statute. And what you had then that followed was this really strange approach to legislating, where you had the Supreme Court doing close by close line reading, using specific grammar to say whether some regulatory language matched some statutory language, as if that was a process that they could do for every regulation that we have on the books in this country. The hundreds of thousands of regulations on the books. Is that something the Supreme Court can do? Obviously not. But when you have a connected industry that has the political connections that can get a case before the Supreme Court, then maybe, yeah, they do have the time for one of the cases they're going to hear in any given year. They could spend the time giving some close analysis, a quick second guessing of some regulatory action against this favored political constituency of not just the gun industry, but some of the more extreme elements of it, selling these conversion products. And what the Supreme Court doing that process said is, if you look at the grammar here, and you look at the physical way that the firearm is operating, we're going to ignore the fact that automatic fire from a bump stock is functionally indistinguishable from automatic fire from an M16, that if you're the person being shot, it looks exactly the same. And we're going to instead look at whether, not from the perspective of the shooter either, from the perspective of a shooter, if you're shooting a bump stock, you pull back your trigger, the gun is sliding back and forth, and it's discharging until you lift up your finger or the magazine is exhausted. It's going to be the same firing from a traditional machine gun. But instead of looking at the perspective of the person being shot or the shooter, we're going to look at the perspective of the trigger, of the mechanical piece on there. And they said in a bump stock equipped firearm, the trigger is actually moving back and forth, whereas in a traditional machine gun, the trigger is not moving back and forth. So it doesn't matter that the shooting is the same. It doesn't matter that for the shooter, it's the same. We're going to have this really technical, narrow reading of the statute. We're going to look at the trigger itself, and we're going to say from there that this characterization of these parts as machine guns doesn't follow the statute. And so they struck down that regulatory action. I think that was a very poorly decided case. But I also want to be clear that that doesn't mean that bump stocks are illegal in Nevada. They're not, because the state legislature took action. And if every state legislature was as good as Nevada on that issue, had the courage of our legislators in Nevada on that issue, then we would be in a much better place as a country.
Right. I guess there's still an opportunity, sort of Nevada showing the way that these things can be legislated for legislatures elsewhere, Congress, to take action where the Supreme Court has stepped in to strike down those ATF regulations.
Yeah, that's exactly right. There are a number of instances where you've had regulatory actions at the federal level. They're always going to be challenged by the gun industry. That's, they've really created a pocket industry of lawyers whose entire business is bringing these kinds of cases, is trying to challenge common sense gun safety regulations. And they have an extra tool in their toolkit if they're suing over something ATF did than suing over something a state legislature did. Our state legislatures have the police power, and they should use it.
Okay. Well, and I guess just to wrap up, I think looking forward, there's been, so much progress, but also, like we've been talking about, right, issues with the courts, that it's not just sort of a straight line up, right, sort of fixing the gun violence issues in this country. So what happens next? I think, what do you think are the policies that ought to be the main focus for folks who are interested in being part of the solution to this problem?
I think that there are a large range of policies that we should be supporting, we should be advocating for, and we should be pushing forward. One I want to particularly highlight that I think is a really interesting and innovative solution, and actually was first enacted at the same year as the ghost gun law in Nevada, so 2021, first in New York, and now in 9 states across the country. And that's a policy that puts the onus on members of the gun industry to act responsibly and has the power of the purse behind it. So it's a policy that we call industry accountability that says that if you're going to be in the business of selling guns, you have to act responsibly. You have to have reasonable controls in place that allow you to prevent unlawful sales, that prevent sales to people who shouldn't have guns. Common sense stuff that responsible members of the gun industry are doing anyway, and irresponsible members of the gun industry are not, and are kind of perversely getting some benefits in the marketplace, because if they're not doing the kinds of compliance work that any responsible person would do, well, that's going to save them a little bit of money. And if they're selling to people that a responsible person wouldn't sell to, well, that's going to generate some revenue from those sales that shouldn't have happened and that may have been unlawful. So what these kinds of statutes say is that if somebody is engaged in that kind of unlawful conduct, if they are selling guns to people they shouldn't, if they're harming our community, they could be sued in our courts. And that kind of accountability is something that puts the onus on those irresponsible companies and says it's going to affect your bottom line if you don't institute the kinds of reasonable processes that anyone else, a responsible person in the gun industry, would be instituting. So I think that has a real potential to push gun safety forward in this country, because it will make it financially incentivized for everybody to be as responsible as the most responsible actors are.
Absolutely. And as we've heard, as we've been discussing this whole thing, I think those financial incentives matter a lot, certainly to the gun industry, which has been trying to defeat all of these measures through the courts.
I think that's exactly right. I mean, we know that irresponsible actors in the gun industry are the big drivers of the gun violence problem. Now, that has for years been irresponsible gun dealers who look the other way for sales that they shouldn't, who facilitate traffickers. It's been the ghost gun industry that's tried to ignore it altogether. It's been people like bump stock sellers who've been putting extraordinarily dangerous weapons in the hands of people who shouldn't have them. So it's those extreme actors, those bad actors that we really need to focus on, that need to be held accountable and that can't profit from their misconduct.
Absolutely, absolutely. Well, David Pucino, Legal Director and Deputy Chief Counsel at the Giffords Law Center, thanks so much for joining Out in Front.
My pleasure, Jacob.